Before you pay another bill, watch this video because you might be throwing money away. Updated 2025 laws have created new protections for seniors, but many companies aren't telling you about these new protections. There are specific types of bills that you are not legally obligated to pay, and the consequences for ignoring them are not what you think. In fact, 73% of seniors successfully overturned wrongfully denied medical bills in 2025 when they knew their rights. I'm going to walk you through each one and explain exactly why you don't owe them. We'll start with the bills that affect seniors most, then move through debt collection tactics, utility protections, and financial programs you may not know exist. Medical bills insurance companies wrongfully denied. Medical bills wrongfully denied by insurance companies are hitting seniors harder than ever, with 45% of insured adults receiving bills for services they believed should have been covered. The problem is that less than half of seniors challenge these billing errors, often because they don't know they have the right to fight back. When seniors do appeal, nearly 40% see their bills reduced or eliminated entirely, proving that most of these denials can be overturned. Insurance companies have developed new strategies to reject valid claims, counting on seniors to give up and pay out of pocket. They use computer systems that automatically flag certain procedures as unnecessary, even when your doctor ordered them specifically for your health condition. The insurance company profits every time you pay a denied bill instead of fighting it. What makes this worse is that 17% of seniors are denied coverage for care recommended by their doctors, and these denials often lead to significant delays in getting necessary treatment. The 2025 federal healthcare regulations created stronger appeal protections for seniors that insurance companies aren't advertising. The new rules require insurance companies to provide detailed written explanations for every denial, including the specific medical criteria they use to make their decision. They must also include information about your right to appeal and the exact steps you need to take. Previously, insurance companies could send vague denial letters that left seniors confused about their options. The new 2025 appeal timeline gives seniors 180 days to file their first appeal, which is triple the previous deadline. This extended timeframe recognizes that seniors often need more time to gather medical records and understand their rights. The Affordable Care Act grants people the right to appeal decisions made by their health insurers, regardless of their insurance type or state of residence. Despite these protections, 45% of those who didn't challenge their insurer's coverage denial reported they weren't sure they had the right to do so. Patient advocacy programs launched in 2025 specifically help seniors navigate the appeal process at no cost. These programs are funded through settlements with insurance companies that violated consumer protection laws. The advocates understand the specific requirements and medical terminology that insurance companies use to deny claims. They can contact your doctor's office directly to request additional documentation and ensure all paperwork is filed correctly. Seniors who use these advocacy services see success rates jump to 89% for overturned denials. Here's exactly how to challenge a denied claim using the 2025 legal framework. First, call your insurance company within 48 hours of receiving the denial and request a detailed written explanation. Ask specifically why the claim was denied and what medical criteria they used. Second, contact your doctor's office and explain that your claim was denied. Ask them to review the codes they submitted to make sure everything is accurate. Third, gather all medical records related to the denied service, including notes from your doctor explaining why the procedure was necessary. Submit your formal appeal in writing within the extended 180-day window. Include copies of all medical records, a letter from your doctor explaining the medical necessity, and any additional documentation that supports your case. Keep copies of everything you send and use certified mail to prove the insurance company received your appeal. If your first appeal is denied, you have the right to request an external review by an independent medical professional who doesn't work for your insurance company. The most effective strategy for 2025 appeals involves highlighting any violations of the new federal requirements. Insurance companies must now provide specific medical evidence to support their denial decisions. Point out any inconsistencies between their denial reason and your doctor's medical records. Insurance companies often use generic denial templates that don't match the specific details of your case, and calling attention to these discrepancies strengthens your appeal. Many seniors don't realize that hospitals and insurance companies profit from confusion about appeal rights. When you pay a denied medical bill, the hospital gets paid, and the insurance company keeps the money they should have paid for your covered services. This creates a financial incentive for both parties to discourage seniors from filing appeals. They make the process seem complicated and time-consuming, hoping you'll give up and pay the bill yourself. The success rate for medical bill appeals has reached impressive levels when seniors follow the complete appeal process. CMS data shows that approximately 83% of prior authorization reversals are successful when properly appealed. Emergency room claims have particularly high success rates, while prescription drug denials tend to be more challenging. Claims involving mental health services saw significant improvement in 2025, with success rates increasing substantially from previous years. Document everything throughout the appeal process because this documentation can be used to file complaints with state insurance commissioners. Keep records of every phone call, including the date, time, and name of the person you spoke with. Save all emails and letters from the insurance company. Take notes during phone conversations and follow up with written summaries. This documentation becomes crucial if you need to file a complaint against the insurance company. The new 2025 medical bill appeal process gives seniors more power than ever before to fight wrongful denials. Insurance companies can no longer hide behind vague denial letters or impossible deadlines. The extended timelines, mandatory advocacy programs, and detailed explanation requirements create a system that actually works for seniors instead of against them. Every denied claim you successfully appeal saves money and helps other seniors by forcing insurance companies to follow the rules. But medical bills aren't the only area where seniors are being taken advantage of. There's another type of debt that collectors are using to extract money from seniors, even when the law says you don't owe it anymore. Debt past the statute of limitations. Debt collectors are targeting seniors with old debts that legally cannot be collected anymore, and they're counting on you not knowing this. These collectors specifically target older adults because they know seniors are more likely to pay debts out of guilt or fear, even when the law says they don't have to. Every state has something called a statute of limitations on debt, which means creditors only have a certain number of years to sue you for unpaid bills. Once that time period expires, the debt becomes legally unenforceable, but debt collectors will still try to collect it anyway. Most states have statute of limitations periods between 3 to 6 years for credit card debt and medical bills. After this time expires, creditors cannot take you to court to force payment. Alabama has a 3-year limit on credit card debt, while Illinois extends it to 5 years. The key is knowing your state's specific rules and when the clock started ticking on your particular debt. Even though the debt still exists on paper, collectors have no legal power to garnish your wages, freeze your accounts, or take any court action once the statute of limitations expires. Debt collectors use fear tactics and misinformation to pressure seniors into paying expired debts. They might tell you that not paying will ruin your credit score, but the truth is that most old debts have already fallen off your credit report after 7 years. They might threaten to garnish your wages or freeze your bank accounts, but they cannot take legal action on expired debts. Some collectors even lie and claim they can have you arrested for not paying, which is completely false. These scare tactics work because many seniors don't understand their legal rights regarding old debt. The most dangerous trap is when debt collectors try to trick you into restarting the statute of limitations on old debts. They might call and say something like, "We're calling about your old credit card account. Can you confirm your address so we can send you payment options?" If you acknowledge the debt or make any payment, you might accidentally restart the legal clock. They also send official-looking letters that ask you to dispute the debt within 30 days, knowing that many seniors will call to discuss the debt instead of sending a written dispute. Even saying, "I remember that debt, but I can't afford to pay it right now," can restart the statute of limitations. When debt collectors contact you about old debts, you have the right to demand debt validation under the Fair Debt Collection Practices Act. This means they must provide written proof that includes the name of the original creditor, the exact amount owed, and documentation showing the debt is legitimate. You must request this validation in writing within 30 days of their first contact. If collectors cannot provide this validation, they are legally prohibited from continuing collection efforts. Many collectors cannot meet these requirements for very old debts because the original documentation has been lost or destroyed. Cease and desist letters are your most powerful tool for stopping collection calls on expired debts. These letters must be sent via certified mail and include specific language demanding that all communication stop. Once a collector receives your cease and desist letter, they can only contact you to confirm they will stop calling or to notify you of specific legal action. If they continue calling after receiving your letter, they are violating federal law. The letter should clearly state that you dispute the debt and request written validation of the amount owed and proof that the debt is within your state's statute of limitations. When debt collectors contact you about old debts, use these specific approaches to protect your rights. If they call, say, "I am not acknowledging this debt, and I want all communication in writing. Do not call me again." If they ask you to confirm information, say, "I will not discuss this debt over the phone. Send me written validation as required by law." If they offer payment plans, say, "I am not making any payments until you provide written proof that this debt is valid and within the statute of limitations." Never agree to anything over the phone, and always follow up with written communication sent via certified mail. Document every conversation by writing down the date, time, and what was discussed. This documentation becomes crucial if you need to file complaints with the Consumer Financial Protection Bureau or your state's Attorney General's office. If collectors continue pursuing expired debts after you've sent proper validation requests and cease and desist letters, you can file complaints that may result in investigations and penalties against the collection agency. The key to protecting yourself is understanding that expired debt cannot hurt you legally, but only if you know your rights and use them correctly. Debt collectors profit from senior confusion about these laws, but federal protections give you real power to fight back. Never acknowledge old debts over the phone. Always demand written validation. And remember that the statute of limitations gives you complete protection once it expires. Understanding your rights with expired debt is crucial, but debt collectors have developed new tactics in 2025 that go far beyond trying to collect old debts. The methods they're using now would have been completely legal just months ago, but new federal regulations have changed everything about how collectors can contact you. Collection agency tactics, now illegal under 2025 laws. The Fair Debt Collection Practices Act has always prohibited harassment, false threats, and contacting third parties about your debts, but many seniors don't know these protections exist. Debt collectors cannot call you more than 7 times in a 7-day period, and they cannot call within 7 days after speaking with you about a particular debt. They cannot call before 8 a.m. or after 9 p.m. in your time zone. And they cannot call you at work if you tell them your employer prohibits personal calls. These rules apply to all consumers, but collectors often assume seniors won't know their rights and will accept abusive treatment. Collection agencies violate federal law when they use threats or harassment to pressure seniors into paying debts. They cannot threaten to have you arrested, claim they will garnish your Social Security benefits, or tell you that not paying will result in criminal charges. Unpaid debt is a civil matter, not a criminal one, and collectors who make these threats are breaking the law. They also cannot contact your family members, neighbors, or friends to discuss your debts or pressure them into paying debts they did not incur. When debt collectors contact you, they must provide validation information either during the first contact or within 5 days. This includes the collector's name and address, the creditor's name, the exact amount owed, and instructions on how to dispute the debt. If you believe the debt is not yours or the amount is wrong, you have 30 days to dispute it in writing. Send your dispute letter by certified mail with a return receipt to ensure the collector receives it. The collector must then stop collection efforts until they provide written verification of the debt. The most effective way to stop collection calls is to send a cease and desist letter demanding that all communications stop. This letter must be sent via certified mail and should clearly state that you want no further contact about the debt. Once collectors receive this letter, they can only contact you to confirm they will stop calling or to notify you of specific legal action. If they continue calling after receiving your letter, they are violating federal law and you can file complaints against them. Collectors often use deceptive practices, hoping seniors won't recognize the violations. They might claim to be attorneys when they are not licensed to practice law, or use official-sounding names like Federal Recovery Services to make seniors think they represent government agencies. Some collectors send letters with fake law firm letterheads to make their communications appear more threatening. These deceptive practices violate the Fair Debt Collection Practices Act regardless of when they occur. If collectors violate the law, you can file complaints with the Consumer Financial Protection Bureau through their online portal, by phone, or by mail. The CFPB forwards complaints to appropriate agencies and tracks patterns of abuse by specific collection companies. You can also sue collectors who violate the Fair Debt Collection Practices Act and collect up to $1,000 per violation, plus attorney fees and court costs. Document every interaction with collectors, including dates, times, and what was discussed, because this documentation becomes crucial evidence if you need to file complaints or lawsuits. Phantom debts are another common problem, where collectors try to collect on debts that either don't exist or have already been paid. These collectors hope seniors will pay without questioning the validity of the debt, especially when they use threatening language or official-sounding names. Never acknowledge a debt over the phone or make any payments until you receive written verification that includes the original creditor's name, the exact amount owed, and documentation proving the debt is legitimate and within your state's statute of limitations. Collection agencies that repeatedly violate consumer protection laws face serious penalties from federal and state regulators. The Consumer Financial Protection Bureau can impose significant fines, and state licensing boards can revoke collection agency licenses. The Federal Trade Commission can also ban collection agencies from the industry permanently if they systematically violate consumer protection laws. Individual collectors can lose their personal licenses and face criminal charges if they use threats or harassment against consumers. The key to protecting yourself from collection agency abuse is understanding your rights and using them consistently. Never discuss debts over the phone. Always demand written verification and send cease and desist letters when you want contact to stop. Keep detailed records of all communications and don't hesitate to file complaints when collectors violate the law. The Fair Debt Collection Practices Act gives you real power to fight back against abusive collection tactics, but only if you know these protections exist and use them properly. Understanding your rights with debt collectors is crucial for protecting your finances, but collection calls aren't the only area where seniors face financial pressure they don't have to accept. Many seniors are struggling with essential services without realizing that significant help became available this year. Utility bills during financial hardship. Utility bills create the biggest monthly expense for many seniors, yet most don't know about assistance programs that could cut their costs dramatically. The Low-Income Home Energy Assistance Program received significant updates that make it easier for seniors to qualify and receive benefits. The income limits for LIHEAP assistance allow seniors earning up to 150% of the federal poverty level to qualify, which means a single senior making up to $22,590 per year can receive help with energy costs. The program provides assistance with electricity, gas, heating oil, and other energy expenses throughout the year, not just during peak seasons. LIHEAP applications require proof of income, Social Security number, and recent utility bills. Most programs accept Social Security statements as proof of income, eliminating the need for tax returns or complicated documentation. Seniors can apply online through their state's LIHEAP website or call the National LIHEAP Hotline for application assistance. Applications are typically processed within 10 business days, and emergency assistance can be approved within 24 hours for seniors facing immediate shutoff threats. Utility companies offer senior-specific discount programs that many older adults never hear about. The California Alternate Rates for Energy program provides a 20% or more discount on gas and electric bills for eligible low-income customers. Similar programs exist in other states under different names, but they all provide substantial savings for seniors who meet income requirements. PG&E and other major utilities offer these discounts, but companies rarely advertise them because discount programs reduce their revenue even though they receive government reimbursements. Many utility companies have policies that prevent shutoffs for seniors during extreme weather conditions. Federal regulations require utilities to maintain service for seniors over 65 when temperatures create dangerous conditions. The protection periods typically run from November through March for heating and June through September for cooling. Seniors cannot be disconnected during these periods, even if they have passed due balances, and utility companies must restore service immediately if it was previously disconnected during protected weather periods. Additional senior protection policies exist at many utility companies that go beyond federal requirements. Some companies cannot disconnect seniors who have medical equipment that requires electricity, such as oxygen concentrators or dialysis machines. Others provide extended payment plans that allow seniors to spread past due balances over 12 months without interest charges. Certain utilities offer senior-only customer service lines with representatives trained to help older adults navigate assistance programs and understand their bills. Utility companies often fail to inform seniors about available assistance programs because these programs reduce their revenue. Companies receive government reimbursements for discount programs, but these payments are sometimes less than the full retail price of services. Many utilities only mention assistance programs in small print on bills or bury information deep on their websites. Some companies train customer service representatives to avoid discussing discount programs unless customers specifically ask about them, which violates consumer protection laws in many states. Payment plan options provide flexibility for seniors struggling with utility bills. Most utility companies offer budget billing programs that spread seasonal costs over the entire year to prevent high winter or summer bills. Extended payment plans allow seniors to spread past due balances over longer periods, and many companies waive setup fees for seniors who demonstrate financial hardship. These payment arrangements help seniors avoid service disconnections while managing their monthly expenses on fixed incomes. Weatherization assistance programs provide free home improvements that can reduce utility bills permanently. These programs offer services including attic and wall insulation, weather stripping, storm windows, and energy-efficient appliances. The programs also replace old heating and cooling systems with high-efficiency models at no cost to seniors. Mobile homeowners and seniors who rent can also receive weatherization services with landlord permission. The average weatherization project can reduce energy costs significantly over time. Here's exactly how to apply for utility assistance programs. First, contact your electric, gas, and water companies directly and ask to speak with someone about senior discount programs. Most companies have dedicated staff for these programs who can check your eligibility immediately over the phone. Second, visit your local area agency on aging office, which coordinates multiple assistance programs for seniors. They can help you apply for several programs at once and provide additional resources for managing utility costs. Third, apply online through your state's LIHEAP website or call the National LIHEAP hotline at 1-866-674-6327 for application assistance. The application process requires basic documentation that most seniors already have available. Fourth, contact nonprofit organizations like the Salvation Army and Catholic Charities, which offer emergency bill assistance for seniors facing immediate shutoff threats. These organizations can provide temporary help while you apply for longer-term assistance programs. The California Public Utilities Commission provides resources and information on assistance programs for seniors living in California. Other states have similar regulatory agencies that oversee utility assistance programs and can provide guidance on available options. Seniors should also check with their local social services office to explore government assistance options beyond utility-specific programs.